We have a major break tonight to tell you about in the death of a North Texas teen. It was supposed to be a fun day of fishing for 3 young men at Lake Ray Hubbard. Instead, it turned deadly after the group jumped in to swim, and 18-year-old Daniel Irving never resurfaced. Now, months later, police have arrested a 19-year-old they say tried to cover up and hide what actually happened that day.
We just want to know. We just want to know what happened and why our baby didn't come home.
2 teenagers in Texas were just arrested, not for causing their friend's death, for what they did with his phone. They threw it into a ditch on the side of the road. One of them went a step further and deleted every single text message and conversation he had ever exchanged with the boy who drowned. Every last one, gone. And that deliberate sequence of choices, made in the hours after a friend went under and never came back up, is what built the entire criminal case against them. Now hold that thought, because roughly 2,000 miles away, in a case that has gripped this entire country for weeks, there is a phone at the center of that story too. Missing content, deleted messages, a grieving mother who says she found and accessed that device before investigators ever formally got their hands on it. If a phone thrown into a roadside ditch was enough to produce felony charges in Texas, the question sitting at the middle of everything tonight is this: what does that mean for the phone sitting at the center of the Nolan Wells investigation? Tonight, that question gets examined alongside a fresh autopsy finding, an FBI statement, and the account of a young woman whose version of Nolan's final minutes on that island does not line up with what his friends have told investigators. This is the update this case has been waiting for, and it starts in Texas. If you are new here, this channel covers true crime cases with depth, context, and the kind of careful analysis that the headlines rarely provide. Hit that subscribe button right now so you never miss a case breakdown like this one, and drop a like on this video before we go any further. It helps more people find stories that deserve to be heard. Before going a single step further, something important needs to be said plainly. These are 2 entirely separate legal cases. 2 separate families, 2 separate states, 2 separate sets of documented facts. Nothing presented tonight is claiming these cases are identical, or that what happened to one young man definitively tells us what happened to the other. What is being done tonight is something narrower and genuinely more useful. These 2 stories are being placed next to each other honestly, so that a fully adjudicated legal outcome in one case can illuminate what remains possible and what remains unproven in the other. That distinction between possible and proven is going to matter every single time it comes up, and it will come up often. So here is what actually happened in Texas, because it is the reason this entire update exists. 18-year-old Daniel Irving went to Lake Ray Hubbard near Dallas on April 13th with 2 friends. One of them was 19-year-old Lucas Rohr. The other was a 17-year-old whose name has not been released publicly. According to a formal arrest affidavit, all 3 of them jumped from a railroad bridge into the water below. Daniel surfaced once after hitting the water. He called out for help, and then he went under. He never came back up. What happened in the minutes and hours that followed is the part of this story that eventually produced criminal charges. And it is worth walking through carefully, because the sequence described in that affidavit does not read like 2 frightened teenagers frozen in shock. It reads like a series of deliberate decisions made one after another, each one building on the last. According to the affidavit, Rohr and the younger teen did not call 911. They did not call Daniel's mother. They left the scene. Along the way, they stopped and discarded Daniel's clothing into a nearby tree line. Then they took his cell phone and threw it into a roadside ditch. Rohr later admitted directly to detectives that he had deleted every text message and conversation he had ever exchanged with Daniel. He said he did it specifically because he knew an investigation was coming, and he did not want to get in trouble. 3 months after Daniel went under and never came back up, on July 9th, Dallas police arrested both of them. Not for causing his drowning, for tampering with physical evidence. A 3rd-degree felony in Texas, tied directly and specifically to what they did with his belongings and his phone in the time between watching him disappear and eventually speaking to investigators. It is worth sitting with what that sequence actually looks like when laid out in order. Driving away from the scene, stopping somewhere separate, disposing of a phone in a location where it would not easily be found, returning to a device and deleting a private conversation history because a legal investigation felt like an inevitable consequence of what had just happened. Fear can sometimes explain why someone doesn't immediately reach for a phone and call for help. It is a much harder thing to stretch across an entire chain of separate, deliberate actions carried out over what appears to have been a meaningful stretch of time. Here is the single most important legal detail in Daniel's case, and it is the one worth carrying directly into everything that follows tonight. The Dallas County Medical Examiner had already ruled on Daniel's death before these arrests happened. The official finding was drowning. The official manner of death was accidental. That ruling came first. The felony charges came later, and the ruling was not reversed or challenged by the arrests. It remains exactly what it was. What that means in plain terms is this. The same official document that says Daniel Irving's death was a tragic accident sits in the same legal file alongside felony criminal charges against the two people who were present when it happened. That is not a contradiction. It is two entirely separate legal questions receiving two entirely separate answers, independently of each other. One question is, how did Daniel die? The official answer is drowning, manner accidental. The second question is, what did the people present do in the time that followed? The answer to that question, according to a Dallas County arrest affidavit, is that they allegedly committed a crime, deliberately, knowingly, in an attempt to protect themselves from the scrutiny they already knew was coming. This is the legal framework that matters most for understanding Nolan's case. A family does not have to choose between accepting that a death was accidental and still demanding accountability for what happened afterward. Daniel's case proves both outcomes can exist simultaneously, in the same file, at the same time. Legal observers who have commented publicly on the Texas case have drawn a specific distinction worth naming directly. Failing to immediately report a death and actively taking steps to dispose of evidence connected to that death are two very different things under the law. The first, not calling for help right away, can sometimes be attributed to panic, fear, or confusion in an overwhelming moment. Courts understand that. Prosecutors understand that. The second, making a series of active choices to alter or remove physical evidence, requires a level of deliberate decision-making that is considerably harder to explain away as pure fear operating in real time. That distinction is exactly what separates a group of frightened young people who simply froze and failed to act from a group who, once the moment for simply calling for help had already passed, shifted into something different entirely. Whichever category eventually applies to the people present in Nolan Wells's case, if charges are ever filed there at all, will likely determine how that story ultimately ends. Ben Crump, the civil rights attorney who now represents both of these families, has not been quiet about drawing this comparison publicly. His language in describing both cases has been strikingly and deliberately similar.
Justice for Daniel Irving.
Justice for Daniel Irving.
Speaking about Daniel, he stated plainly that two young men came to Daniel's house, picked him up, went fishing and swimming with him, and came back without him. Anyone who has followed the Nolan Wells case will recognize immediately why that framing lands with such force, because almost the same sentence applies. Reverend Al Sharpton, who appeared alongside Nolan's family at multiple press conferences, has used similarly measured language, refusing to declare either case a closed instance of anything specific, while consistently arguing that the pattern itself, delayed reporting, missing or compromised evidence, and official conclusions delivered before full evidence was gathered, deserves genuine public scrutiny regardless of what ultimately caused either young man's death. Both men have worked to maintain a precise distinction publicly. This pattern deserves scrutiny is not the same statement as this pattern proves a specific crime. That difference matters, and it matters that both Crump and Sharpton have largely held to that line even as public conversation around both cases has at times moved well past it on its own. For anyone coming to Nolan's story for the first time tonight, here is where this case actually stands. 18-year-old Nolan Wells was a wide receiver at Southwest Mississippi Community College, heading into what was anticipated to be a full and promising first season with the program. On July 4th, he went to Horn Island with a group of friends. Horn Island is a remote, federally protected barrier island off the Mississippi Gulf Coast, located roughly 12 miles offshore, accessible only by boat, with no permanent residents and no reliable cell service infrastructure. Nolan did not return from that island with his friends. His body was recovered from the water 2 days later, on July 6th. His friends told investigators that he had chosen to stay behind on his own, saying he planned to catch a ride back with someone else. He did not have his phone on him when his body was recovered. He did not have his keys. Both items turned up later in a friend's possession rather than his own. Around 11 that night on July 4th, one of the friends contacted the Coast Guard. but the Jackson County Sheriff's Office did not formally request Coast Guard assistance until approximately noon the following day. That is a 13-hour gap between the first contact and a formal search request. That gap has never been fully explained in any public statement. The Jackson County Sheriff's Office stated early in the investigation that it suspected accidental drowning and did not suspect foul play. That statement was made before the state's own autopsy results had returned. Nolan's family did not accept that conclusion. They retained civil rights attorney Ben Crump. They arranged for Nolan's body to be transported to Washington, D.C. for an independent second autopsy, funded in part by Colin Kaepernick. And they brought Reverend Al Sharpton alongside them as the case drew national attention. The independent autopsy was conducted by Dr. Roger Mitchell, a forensic pathologist and the president of the National Medical Association, on July 10th. His conclusion was announced publicly at a press conference in Chicago. His ruling was that the cause and manner of Nolan Wells's death remain undetermined, pending further investigation. That word, undetermined, lands very differently when it follows an official office declaring the death accidental before the tests were even complete. Alongside that ruling, Dr. Mitchell documented a specific physical finding: a focal area of red discoloration in the deep, soft tissue on the back of Nolan's head, measuring approximately 12 inches by 8 inches. The skin above that area showed no damage, no laceration, no abrasion. The bone beneath it showed no fracture. The finding is real. It is documented. And as of tonight, it has not been publicly explained. Ben Crump has stated that Dr. Mitchell cannot rule out foul play, specifically injury to the neck, in part because the state medical examiner had already retained Nolan's trachea and hyoid bone before the independent examination took place. Those are the anatomical structures most relevant to evaluating potential neck injury. They were not available to Dr. Mitchell when he conducted his exam. More detailed reporting since that press conference has characterized the retention of those tissue samples as consistent with standard procedure between two separate autopsies conducted at different times, rather than evidence of deliberate interference. Both things can be true simultaneously. This was likely an ordinary procedural step, and it still placed a documented limitation on what the independent examination could confirm on its own. Toxicology results from both the state examination and the independent autopsy remain outstanding. That single missing test is what the entire medical and legal picture in this case is still waiting on. The reason toxicology carries this much weight is worth understanding precisely. Drowning produces fluid accumulation in the lungs caused by the body's oxygen deprivation disrupting normal biological function. A drug overdose can produce that same fluid accumulation through a remarkably similar physiological process. Examining the lungs alone often cannot reliably distinguish between the two. That is why drowning in forensic pathology is treated as what is called a diagnosis of exclusion. It is a conclusion reached only after the alternatives, particularly overdose, have been systematically ruled out through testing. Toxicology is the specific tool that performs that elimination process, and it typically takes several weeks to produce reliable results. There has been no suggestion at any point that drugs played any role in what happened to Nolan Wells. This explanation exists purely to clarify why a definitive cause of death cannot simply be issued without that test being completed and reviewed first. The discoloration finding documented by Dr. Mitchell deserves to be understood precisely, rather than exaggerated in either direction. 12 inches by 8 inches covers a substantial portion of the back of a human skull. It is large enough that a careful, thorough pathologist would want a documented explanation for it, rather than simply noting it as an incidental observation and moving on. But size alone does not establish cause. Discoloration of that nature can in some cases result from post-mortem blood pooling depending on how a body was positioned after death and for how long, particularly following several days in warm Gulf waters. It is exactly this kind of genuine ambiguity, a finding that is real and documented but not yet fully explained, that makes the comparison between Nolan's case and Daniel's so instructive. Daniel's medical examiner reached a clean, confident ruling. Nolan's independent examiner reached the opposite, an honest acknowledgement that the evidence available to him was not sufficient to reach a confident conclusion in either direction. Now here is the thread that connects back to the central contradiction that has defined this entire investigation from the beginning. A young woman identified publicly only by her first name, Katie, is described as the last person confirmed to have spoken with Nolan before he disappeared on that island. For weeks, her account existed only secondhand, passed through her mother and sister in social media posts, attempting to correct rumors that had been spreading without any factual anchor to hold them in place. That changed. Katie sat down directly, face-to-face with Nolan's mother, Christine, and according to Christine, what Katie told her in that meeting does not match what the friends have said. The nuance here matters, and it is worth being precise about it. According to Katie, Nolan told her that he intended to head back and rejoin his friend's boat before they left the island. According to the friends, Nolan told them the opposite, that he wanted to stay behind voluntarily, by his own choice. Katie never actually watched Nolan board that boat. She is describing an intention he stated to her directly, not something she personally witnessed. That distinction is important. This is not necessarily a situation where one person is lying and another is telling the truth. It may mean something changed in the gap between Nolan stating that intention to Katie and whatever happened next. A gap that no one has been able to account for publicly. What this meeting represents is the first time Katie's account has come directly from her to the person who needed to hear it most, without being filtered through relatives or processed through a chain of second-hand retelling. For nearly 2 weeks, one of the most critical accounts of Nolan's final minutes existed only as second-hand information. That gap allowed speculation and misinformation to fill the space where Katie's actual words should have been. A direct, private, in-person meeting closes that gap in a way that no press conference or formal statement could have. There is a parallel running quietly through both of these cases that deserves to be named directly. Christine Wells has described tracking Nolan's phone herself before investigators formally obtained the device. She and her sister accessed his Snapchat account and found that what was there did not match what she expected from a son who regularly documented outings and events like the one he went on that day. Tamika Erving has described a similarly frustrating experience with the system surrounding Daniel's case. She was informed by police that Daniel's phone could not be searched for until after his body had already been recovered, due to legal restrictions on locating a device before a person is officially confirmed missing under specific thresholds. A procedural limitation, a bureaucratic caution built into the system. In both cases, these mothers describe encountering a structure that appeared to prioritize procedural caution over urgency. A structure that, whether by design or by accident, gave anyone with something to hide additional time to ensure that it stayed that way. This is what these two cases, laid next to each other honestly, actually reveal. Daniel Irving's case produced a documented arrest affidavit, felony charges, and a legal record that proves a death officially ruled an accident can still result in criminal accountability for the choices made in the hours that followed. That is no longer a theory. It is an established legal fact sitting in a Dallas County court file. Nolan Wells' case has produced an independent autopsy ruling of undetermined, a documented physical finding on the back of his head that has not been publicly explained, a 13-hour gap in the official search response, a phone recovered from a friend's possession rather than his own, a contradictory account from the last person confirmed to have spoken with him, and a mother who found things on her son's device before investigators did. None of those documented facts, taken individually, constitute proof of anything specific, but taken together, they form a picture that a grand jury referral and an active FBI presence suggest investigators are not prepared to simply close and walk away from. The questions that produced felony charges in Texas are the same questions still circling this case in Mississippi. What happened to this young man is one question. What the people around him did in the time that followed is an entirely separate one. And as Daniel Irving's case just demonstrated in the clearest possible terms, the official answer to the first question does not close the door on the second. Real conversations are still happening in the background of this case, private ones, the kind that don't come with cameras or press statements attached. Conversations between people who were there and people who need answers. And in a case built on contradictions between what was said publicly and what may have actually happened, those quiet exchanges may end up mattering just as much as anything filed in a courthouse. While those conversations continue behind closed doors, this investigation has also drawn something more formal, something institutional. And it is worth being precise about exactly what that means, because precision is what this case demands more than anything else right now. The FBI's Jackson Field office released an official public statement confirming its involvement in the Nolan Wells case. But that involvement is specific and limited, in a way the headlines did not always make clear. According to that statement, the FBI's assistance has centered specifically on interstate threats made against people connected to this investigation, threats serious enough to cross state lines and fall under federal jurisdiction. The statement was also explicit that the Jackson County Sheriff's Office remains the lead agency on the underlying case, from the beginning of this investigation through whatever comes next. Federal support, not a federal takeover. That distinction matters more than it might seem on the surface. Federal agencies routinely assist local law enforcement on cases involving interstate threats, entirely separate from the underlying investigation those threats happen to be connected to. That is the framework at work here. The threats themselves, directed at people tied to this case, are what triggered federal jurisdiction. Not any formal determination that Nolan's death is being investigated as a federal crime. Understanding that keeps this development in its proper context, rather than allowing it to carry more legal weight than it currently holds. At the same time federal involvement was confirmed, this case moved towards something else. Something with potentially more direct bearing on what comes next. Following a formal meeting between Nolan's parents and Jackson County District Attorney Angel Myers-Math, Ben Crump publicly confirmed the case will be presented to a grand jury once the underlying investigation concludes. The district attorney's own office clarified directly that this referral reflects standard procedure for unnatural or suspicious deaths in that county. It is not, on its own, confirmation that criminal charges are inevitable or even likely. Grand jury referrals in cases like this one are procedural steps, not verdicts. Both of these developments, the FBI statement and the grand jury referral, represent real institutional movement. Neither one, standing alone, tells us what this investigation will ultimately conclude. Advocacy groups following both Nolan's and Daniel's cases have now begun treating them together as a single example of a specific, recurring failure point. Not necessarily in how these two young men died, but in what happened in the minutes and hours immediately afterward. In both cases, the people physically present when something went wrong did not immediately involve authorities. In both cases, a phone that should have documented the day instead became a source of suspicion. In both cases, official investigators reached an early conclusion, accidental drowning, no foul play suspected, that the families publicly rejected as premature. And in both cases, an outside attorney and independent resources became necessary simply to secure the same level of investigative scrutiny that advocates argue any family should receive by default, without needing to fight publicly for it first. None of that proves either case involves anything beyond a tragic accident compounded by poor decisions made under pressure. Panic is a genuine, ordinary human response. Not every failure to immediately call for help reflects guilt about causing someone harm. Sometimes it reflects fear of consequences for something else entirely. Underage drinking. The dread of how a chaotic night will look to the adults in their lives. The paralysis of not knowing what to do when the worst thing imaginable has just happened in front of you. Daniel's case demonstrates that distinction directly. The charges filed against Lucas Rohr and the younger teen are for what they did after Daniel went under, not for putting him in danger in the first place. But that same distinction is precisely what both families are still fighting to have taken seriously. The position that even if no one intended harm, choosing silence and self-protection over a phone call for help is its own kind of failure, one that deserves real accountability rather than a quiet accidental ruling that closes the file before every question has actually been answered. The NOC has now formally entered Nolan's case, passing a resolution calling on local, state, and federal authorities, explicitly including the Department of Justice, to conduct a complete and transparent review. That level of institutional weight did not attach to Daniel's case in quite the same way, at least not from a national civil rights organization with that specific reach. Whether that additional organized pressure ultimately changes the pace or the outcome of Nolan's investigation, compared to the 3 months Daniel's family endured before any arrests happened, is itself one of the open questions this comparison leaves unresolved. It is also worth acknowledging directly that these two cases differ in a way that matters for understanding exactly this kind of institutional response. Daniel's case, as reported, did not carry the same specific racial dimension that has been central to public discussion of Nolan's. Nolan Wells was a young black man whose friend group was reported to be predominantly white. That dynamic has shaped which organizations and public figures chose to get involved in his case specifically, and it represents a genuine, distinct layer of this story, separate from the shared pattern around phones, delayed reporting, and early official conclusions that connects both cases on a procedural level. Ben Crump and Reverend Al Sharpton have both raised that racial dimension directly and repeatedly in Nolan's case, while being careful, as covered in Part 1, not to claim it alone establishes what actually happened to him. Understanding both threads, the shared procedural failures and the distinct racial context specific to Nolan's situation, is necessary for seeing this comparison clearly, rather than collapsing either case into a simpler story than it actually is. Now here is where the comparison between these two cases gets genuinely sharp. In Daniel Irving's case, the phone is no longer a family suspicion. It is a documented, charged crime. According to the arrest affidavit, Lucas Rohr and the younger teen physically discarded Daniel's phone specifically to keep it from investigators. And Rohr separately deleted his own communications with Daniel once he understood an investigation was coming. That is an alleged fact sitting inside a criminal filing attached to a felony charge. In Nolan's case, everything currently known about the phone comes from the family's own account. Christine Wells has described tracking the device herself using Life 360 before investigators formally located it. When she and her sister accessed it, she says they found nothing from that entire day. No saved photos, no saved Snapchat content. Despite Nolan's well-documented habit of capturing moments exactly like the kind of outing July 4th represented, the question worth asking directly is whether this phone could become for Nolan's case what the phone became in Daniel's. The single piece of evidence capable of producing criminal charges regardless of what the autopsy ultimately says about cause of death. The honest answer is that it could, but only if it gets confirmed through a process more rigorous than a family looking at the screen themselves. What Christine has described is a troubling and significant observation. It is not yet a forensic finding. A professional forensic extraction is what separates a family's account from evidence with the same legal weight the Texas affidavit carries. And that is precisely why the coordinated phone inspection both sides have agreed to conduct carries so much significance. It is the step that could transform this from a painful family observation into something chargeable on its own, entirely independent of however Nolan's cause of death is ultimately ruled. It is worth walking through exactly what that forensic examination would need to demonstrate to move this phone question from suspicion into something legally comparable to Daniel's case. Investigators or the family's retained experts would need to show that specific content, messages, photographs, Snapchat activity existed on the device at some point during the day of July 4th and was then deliberately removed by a specific person at a specific time. That is a meaningfully higher evidentiary bar than simply confirming the phone currently shows nothing from that day. Digital forensics can often recover data that appears deleted, because very little digital information is ever truly and permanently erased the moment someone presses delete. If that recovery process surfaces content and reveals it was removed during the window when the friends had possession of the device rather than automatically expiring through Snapchat's own built-in content settings, that is the precise kind of finding that turned Daniel's case from a grieving mother's suspicion into 2 felony arrests. Nolan's case is standing at that exact threshold right now, waiting only on an examination both sides have already agreed to conduct. There is a legal caution worth including here that applies to both cases equally. Location tracking tools like Life 360 depend heavily on network signal and coverage. A group of people gathered closely together, all using their devices simultaneously, can genuinely interfere with each other's signal strength, potentially producing exactly the kind of inconsistent location data these families have described as suspicious. That does not make either family's account meaningless or dishonest. It means drawing firm conclusions from consumer-grade tracking applications before a professional forensic download has taken place, risks moving faster than the evidence itself can currently support. That discipline, distinguishing a family's honest and troubling observation from an actual confirmed forensic finding, is exactly what both of these cases now require. Because only confirmed forensic findings can ultimately support criminal charges. There is one more layer to this comparison worth adding, specifically about how tampering charges actually get proven once they have been filed. Prosecutors generally need to establish intent. They need to demonstrate that the person accused knew evidence was relevant to an investigation and acted specifically to conceal, alter, or destroy it. In Daniel's case, Lucas Rohr's own admission to detectives that he deleted messages because he knew an investigation was coming effectively supplied that intent in his own words. That kind of direct, self-supplied admission is what made the tampering charge in Texas relatively straightforward to bring. Without a similar admission, or without forensic proof clearly showing deliberate deletion tied to the specific window of the investigation itself, prosecutors in a case like Nolan's would need to build that same intent circumstantially. Through the documented timeline of who had the phone, for how long, and what a forensic download ultimately reveals was removed and precisely when. That is a heavier evidentiary lift than what Texas prosecutors had sitting in front of them, which is part of why the phone inspection in Nolan's case carries the weight it does. It may be the single piece of evidence capable of supplying the kind of proof this entire comparison keeps returning to. One of the sharpest differences between these two cases has nothing to do with the evidence at all. It has to do with pace. Daniel Irving died in April. It took 3 full months and sustained organized public pressure from advocacy groups, including the Next Generation Action Network, before any arrests happened. People involved in that case have said directly that the urgency it deserved simply was not present in its earliest and most critical days. Nolan Wells died in July. Within roughly 2 weeks, his case had already drawn FBI involvement, national media coverage, a district attorney publicly committing to a grand jury process, and an independent autopsy funded by a former NFL quarterback. That speed, that early in an investigation, is close to unprecedented. That contrast raises an uncomfortable question that deserves to be asked plainly. Did Nolan's case move faster because investigators genuinely prioritized it differently from day one? Or did it move faster specifically because of the intense public and media pressure that built almost immediately? Pressure that simply did not exist for Daniel's family during those same critical early weeks. Advocates following both cases have pointed toward the second explanation. That public attention, more than procedural fairness, is often the actual variable determining how quickly any family receives real answers. If that pattern holds, it suggests whatever comes next in Nolan's case will likely follow the same trajectory Daniel's did. Not institutions moving proactively on their own schedule, but sustained public attention refusing to allow the case to quietly stall. Consider the mechanics of how each of these stories actually reached a national audience in the first place, because that difference may explain the speed gap better than any detail about the underlying facts. Nolan's case had an immediate, visually striking set of circumstances: a remote federal wilderness island, a 13-hour Coast Guard delay, a group photo that circulated widely online within days of his disappearance. Daniel's case, by contrast, unfolded quietly for months in local Dallas area coverage before advocacy groups pushed it into wider view by publicizing his mother's documented frustration with the pace of the investigation. That early difference in visibility may say less about which case investigators considered more serious from the start, and more about which case happened to generate the kind of viral momentum capable of forcing institutions to accelerate beyond their default pace. That is an uncomfortable thought for anyone hoping the justice system treats every grieving family identically, regardless of how loud the public conversation around their particular case happens to become. It also raises a question that neither of these two cases can answer on its own. How many cases shaped exactly like these two have never received this level of scrutiny simply because they never found the national attention that pushed Nolan's and Daniel's stories into view? That question sits underneath this entire comparison without resolution. And it deserves to be heard alongside everything else tonight. Before closing, it is worth listening carefully to what these two families have actually said they want, because it is more modest and more specific than the scale of attention surrounding both cases might suggest. Tamika Erving has not demanded automatic convictions. Her attorney has asked investigators to follow the documented facts wherever those facts lead, and to bring whatever charges those facts actually support. What she has pushed back against is not a specific predetermined outcome. It is 3 months of feeling like no one outside her own advocacy network was treating her son's death with real urgency. Christine and Elmore Wells have said almost the same thing about Nolan. Not a predetermined conclusion. In Christine's own words, the same respect that would be given to anybody else. Two families, thousands of miles apart, who have never met each other, represented by the same attorney, who have independently arrived at nearly identical language for what justice actually means to them. Not a guaranteed result. A guarantee that the process treats their son's life as seriously as any other life would be treated. So does Daniel's arrest actually predict anything specific for Nolan's case? Not directly. These remain two separate legal proceedings moving at two different speeds, built on two different sets of documented facts. But Daniel's case does prove something worth holding on to as Nolan's investigation continues moving forward. An accidental ruling and real accountability are not mutually exclusive. A phone, once it has been forensically examined by professionals, has already been enough in one case exactly like this one to transform a family's suspicion into a felony arrest. Nolan's case is standing right now at the threshold where that same transformation either happens or it doesn't, waiting on an examination both sides have agreed to, two outstanding sets of toxicology results, and a grand jury process that has not yet formally begun. What these two cases share, placed honestly next to each other, is a recurring shape. A friend group that did not immediately call for help. A phone that went missing or showed signs of interference in the hours that followed. An early official conclusion delivered before the full body of evidence had even been gathered. Whether that shape reflects something structural, about how frightened young people tend to behave in these moments, or something more troubling about which victims receive the benefit of the doubt immediately and which receive an early convenient conclusion instead, is exactly the question both of these cases are forcing into public view together. At the center of all of it, past the national media attention, the celebrity funding, the FBI statements, and the grand jury referrals, are two mothers who want to know what happened to their sons in their final minutes, told honestly, by people who were actually there. That is not a demand for a predetermined verdict. It is not a demand that anyone be presumed guilty before the facts are in. It is the same thing any parent anywhere would want if this happened to their own child. Daniel's case shows that asks can eventually be answered, even when it takes 3 months and sustained public pressure to get there. Nolan's family is still in the middle of that same fight, waiting on a phone inspection, waiting on toxicology from 2 separate examinations, waiting on a grand jury process that has not yet begun. Nolan Wells was 18 years old. Daniel Irving was 18 years old. Neither of them is here to say what actually happened in their final minutes. What remains are 2 families still waiting, in Christine's own words, for the same respect anyone else would receive, and a phone sitting at the center of Nolan's case that a case just like his has already proved can be the difference between a quiet accidental ruling and real chargeable accountability for whatever happened after. This channel will keep following both of these cases as the phone inspection takes place, as toxicology results arrive from both sides, and as this investigation moves toward a grand jury. Every development will be brought to you verified, sourced, and precise. Not a moment before the facts are actually confirmed. If this breakdown gave you the context and the clarity this case deserves, now is the time to make sure you do not miss what comes next. Subscribe right now, so you are here when the next update drops. Like this video before you go. It takes 1 second and it directly helps more people find coverage that treats stories like these with the depth and the honesty the families at the center of them have earned. These cases are not finished. Stay with us.